I might not be able to answer or reply to every single one of you, but please feel free to contribute to the discussion, and please feel free to share with me your thought on the discussion. Now, can I just check? My first question to you guys here is that can you, for those of you who are currently doing moot court, for those of you who are currently doing moot court, either in arbitration or in litigation setting or in other court setting, can you please drop a chat saying that I am doing a mooting, maybe in Vismut, maybe in doing Jessup, IHL, or other part? Can you just type in so that I can know the demographics of today's audience? So once again, for those of you who are currently doing mooting, please drop a chat saying that I'm doing mooting, I'm doing Vismut. Just a simple chat like that. For those of you who hasn't, I'm going to go to you later. Okay. So there's no chat for now. So I assume that all of you are beginners. All of you have not experienced mooting before. Oh, sorry, all of you are not currently doing mooting right now. So I can tell you that mooting, they are divided into 2 or 3 parts here. The first mooting is mooting in arbitration setting, like you have Vismut, you have FDI, you have Loasia. Okay, Abdul Hakim used to join NAMCO and Jessup and IHL. So NAMCO is one of the moot that is fall within arbitration setting, but you also have another moot that falls within litigation setting or court setting like IHL or Jessup. Now, for today's particular topic, it might have a direct benefit to those who are joining or interested in arbitration setting, but there might be some people that that might not find this topic particularly benefit because they're doing IHL or JSOP. But don't worry, because you might be interested to join arbitration moot court in the future, or it might be beneficial for your career or your ADR class later on. So I'm gonna share my screen first about the introduction to arbitration. Okay, so I'm gonna go through you about the basic difference with arbitration, litigation, and mediation. So as you know, arbitration, the definition of arbitration, there is no shortage of opinion what is arbitration, but simple definition would be that arbitration is that type of activity when a dispute is submitted to arbitration for a binding decision. And litigation is process of making a claim in court of law, and mediation is negotiation in the face of a third party. Now, arbitration, when it comes to time, it actually takes, it could take a bit long as well. It could take months or a year. It depends on the procedure that is to be agreed by the parties. For litigation, because we have appeal process, this is going to take also months or years. For mediation, this is the fastest among these 3. It just take around days. It depends on the complexity of the case as well as the skill of the mediator. I've seen a case where it's just being solved in 1 day after the parties meet with the mediator, although the dispute has been prolonged for like almost 3 or 5 years, but because the mediator is very skilled, within just 1 day, it's settled. Now, in terms of cost, arbitration, it's higher than mediation. It can also be higher than litigation, but it depends on a lot of factors, whether it is international, whether it is domestic, how many witnesses that you're gonna have. Do you have to pay the cost of the arbitrator? Do you have to fly your team all the way to London? So there are a lot of factors that contribute to the cost in arbitration. For litigation, once again, it depends on the length of the case and complexity of the case. For mediation, once again, it's the lowest among these 3. Yeah, mediation is very cheap. For confidentiality in arbitration, that's something that the parties will be granted. All matters, all things happening in the arbitration that will be kept confidential. For litigation, there's no confidentiality. It's going to be made public. Mediation, there's also confidentiality. Now, when it comes to the third party in arbitration, it's called arbitrator, right? Now, arbitrator, it controls the content and the outcome of the proceeding because they are the one that will make the decision. Now, the parties in arbitration, they somehow have influence when it comes to the appointment of the arbitrator because the parties can say, oh, I want to have, or sorry, the parties can, let's say, let's agree to have an arbitrator that has experience in construction. Or the parties can say, you know what, let's have the AIC to appoint an arbitrator. So when it comes to the appointment of the arbitrator, the parties in arbitration, they have influence. Now, this is not the case in litigation because you cannot choose the judge. You cannot choose what kind of criteria that needs to be professed by the judge. You cannot say, you know what, I want to director of the AIC to appoint the judge. You cannot say that. When you submit your case to litigation, then you really have no influence whatsoever to the selection of the judge or even the legal proceeding itself. But in arbitration, you still have influence to the appointment of the arbitrator, and you also have influence to the procedure of the arbitration itself. Well, for in mediation, you can also have influence in the appointment of the mediator, and yeah, it's all based in parties' autonomy. Now, I'm gonna move on to my second question of the day. Can I ask you, all of you, all 125 participants, and just drop a chat very quickly when when you have a client in front of you. Let's say that you're already a lawyer and then you already graduated, you're already qualified, you're being called to the bar. You have a client right in front of you, and then your client is asking, what is the benefit of arbitration? What would be your answer to your client? Can you drop a chat, please? Why people arbitrate? Anyone want to try? Somehow cannot see the chat. So if MC can help me to let me know if there are any entries from the participants.
All right. So a person stated for specific expertise tailored for the case,
Oh, that is correct.
confidentiality, keep the
Yes,
privacy of company information, especially in
yes,
business setting, to
yes,
ensure the privacy of company details,
yes,
private and confidential,
yes, that's correct.
to get a result that is most likely to satisfy both parties,
Yes, yes, that is absolutely correct.
complete
So most,
confidentiality.
okay, so most of the entries are about confidentiality and privacy. Anything else that worth to be noted?
So far, there's no more answer. The
Okay.
last one would be okay, there's one
Mhm.
formal compared to mediation.
Okay. All right. So I think all of those are a very good answers. But if I can just summarize, there are basically two main reasons why users are going to arbitration. For confidentiality and other reasonings, that's no problem in additional reasons. But for the main reasons, it is my position that there are two. First is neutrality, and the second one is enforcement. Now, neutrality because when it comes to
Mr. Audio, your microphone is muted.
yes, the host muted me just now. I don't know why. Okay, so yeah, when it comes to neutrality, first is that you select an arbitrator that is neutral, that is independent. So that's why you go for arbitration, and then you also have an institution that can also enhance the neutrality of the proceedings. And the third one is that, as being mentioned by a lot of people just now, the expertise can also be, somehow agreed by the parties, which once again is going to enhance the neutrality of the position of the arbitrator. The second one is when it comes to enforcement, and this is a very salient issues when it comes to international arbitration, because if you have international issues involving, international parties, if you submit yourself in one of the domestic court of the party, for example, you guys are from company from Malaysia, and then I'm from Indonesia. We have a dispute, and then what is the possibility that you guys are going to, you guys are willing to subject yourself into Indonesian court? It's very, how do you say? It's very minimum, because if you are Malaysian parties and then you are going to subject yourself into Indonesian courts, not only that there is an issue about neutrality, there's also issue about how are you going to enforce the judgment rendered by Indonesian court to Malaysia or the other way around. So when it comes to arbitration, because of the New York Convention 1958, I will be explaining further about this. It's going to facilitate the enforcement of the proceeding. So that's why people, especially in international users, they prefer to go to arbitration instead of litigation. So yeah, very good answers to every single one of you. Okay. Now, the second one is additional reasons. I think most people talk about confidentiality, which is one of the main reasons, but I didn't see a lot of comments about flexibility. Because in arbitration, once again, the parties, you guys have the power, you guys have the voice to say, you know what, I want to have the venue in Kuala Lumpur, I want to have the venue in Singapore. Um, I want to have the number of the arbitrators, one or three. So you have a lot of control to the proceeding itself. So that's why it's flexible. The last one is also additional power of arbitrator, because you know, I think when it comes to arbitrator, there are certain power that you can grant to the arbitrator that you cannot find in the court. Um, I think, for example, is that when it comes to court, I think back in UK, you cannot have a award for free interest, but when it comes to arbitration, you can do it. So that's one of the additional power of arbitrators that the parties can vest to the tribunal. Now, is arbitration perfect? Um, I know that I'm a case counsel at AIC. I'm supposed to tell you guys that arbitration is perfect, arbitration is the way to go. But honestly, arbitration is not perfect. Of course not. There are certain drawbacks, there are certain disadvantages to arbitration. Now, once again, if you have a client um, asking your advice, um, what would be your advice? What would be your, warning to your client as to what kind of issues that can arise in arbitration? And some of you give an example. And I think somehow now I can see the chats. So I am able to see your entries. So I'm going to repeat my question. My question is, if you have a client asking you, okay, I want to go for arbitration, but can you advise me what is the drawback or what are the issues that can arise in arbitration? What would be your advice? You guys are law students, your graduation will have a lot of clients. So it is your duty to, anticipate, analyze, and, give your client heads up as to what issues that can arise. Now in arbitration, what do you think the issues could be? Any takers? not transparent. It is relatively time consuming and costly, like litigation as well. Issues of binding settlement, which is Shafi, that's a very good answer. And anything else I want to try? I think one thing that I want to highlight is the cost itself, because yes, I think costs would be one of the, one of the issues that you need to advise your client that if your client wants to go to arbitration, you really need to tell them that you really need to prepare your wallet because you're going to um, spend a lot in arbitration, especially if it is international arbitration. Arbitrators might not be able to issue order backed by executive enforcers, lack of formal evidence process. Consent from both parties is needed, which can be difficult if either party. Okay, so for the consent, that is also a very good answer because if you want to go to arbitration, if you want to initiate an arbitration, the other party have to agree on it. The other party have to agree that, okay, let's go to arbitration. But if the other party didn't agree, then we cannot initiate the arbitration. And this agreement, right, can be reflected in the contract. So if the contract contains arbitration clause, then you can initiate arbitration. But if the contract doesn't have, and when a dispute arises, you try to propose that, hey, you know what, now a dispute arises, can we go for arbitration? And the other party says no, then that's it, you cannot go for arbitration. So that could be difficult, yes. Oh, I just realized that you guys have a coding P040 P119. So I'm just gonna mention your code now. Yeah. So all of you have a very unique answers. But when it comes to arbitration, these are several potential problems. The first one is what you call as multi-party arbitration, joinder, and consolidation. And this relates to the answer by P040, which is about the consent. Because once again, if you want to initiate an arbitration, you need to have a consent. Now, what happened? What happened if you want to drag another party to the arbitration? What happened if you want to drag the parent of the company to go to arbitration? You cannot simply drag them into the proceeding if they don't have a consent. That's one of the problems when it comes to arbitrations. If you want to initiate multi-party arbitration, all parties involved needs to have a consent. Um, but the how do you get around with this is that you choose an institutional rules that allows you to drag a third party into the proceedings. So for example, in AIC rules, it is possible for you to, to drag a third party into the proceeding, but there is a requirement. The requirement is that the third party needs to have implied consent to arbitration, not necessarily express consent, but implied consent is enough. Now, the next question is, how do you gather implied consent? How do you determine whether a consent is implied or whether a consent is expressed? So this is going to take another 1 hour to give you a lecture about that. But long story short, implied consent can be inferred from the conduct. So for example, if the parent company, is the one that initiate the performance of the obligation instead of their employees, then that parent company can be deemed to have impliedly consent into the arbitration. So that's it's a very advanced course, which I think for the purpose of today's discussion, we just leave it at that. So implied consent is enough. Now, that also covers the non-signatories, because non-signatories means that how do you drag someone that do not sign the arbitration agreement into the proceeding? Once again, it's possible if that someone have a implied consent into the arbitration. Now, the third one is conflicting awards. Now, unlike litigation, right, in arbitration, there is no principle of stare decisis. So there is no binding precedent. So it is possible that, you know, if you have um, if you have two disputes arising from the same contract, um, the disputes are similar but not the same, and then you initiate two different arbitration for these two disputes, it is possible that the other arbitration says you win, the other arbitration says you lose. It is possible. And you cannot say that, oh, it's conflicting award, how it is possible, how this happened. So in arbitration, that is very possible because once again, there is no principle of stare decisis. A tribunal at best can only regard the other tribunal's decision as a highly persuasive authority, and that's it. And it's not a binding precedent. The fourth one is what we call as judicialization. It means that the process now is becoming rigid. The process now is becoming like a court. But once again, if you have any issues with regard to the procedure, um, the way for you to get around this is to have an institution rules that allows you to have a very flexible procedure. So yeah, that's how you get around judicialization issues. Now for the fifth and sixth, I think that's something that even you guys, students are familiar with, which is about the cost and then the delay. In arbitration, it's gonna be costly if you don't know what you're doing. Delay also, it's gonna be, it's gonna take around months or years. It depends on the complexity of the case once again. Now we have learned about what is arbitration. Now there are two types of arbitration. The first one is administered arbitration. The second one is ad hoc arbitration. Now this classification is very, very crucial because if you're planning to start a career in arbitration, your client is going to ask you about this a lot. So I cannot emphasize enough how important it is for you guys to understand the basic difference about administered and ad hoc. Now, administered arbitration, as the name suggests, as the name implies, it means that that arbitration is being administered by a certain institution like AIC. So if the arbitration clause, and you're going to see this a lot more later, if the clause says that this arbitration is to be governed under AIC rules, then it is administered arbitration. Now, administered arbitration is very easy for you to understand. Some people have difficulty to understand what ad hoc arbitration is. Now, ad hoc, as the name suggests, it derives from this Latin word that basically says you go alone. Now, ad hoc means that, yeah, you go alone. There is no institution, there is no arbitration institution that administer your proceeding. When it comes to ad hoc arbitration, because there is no institution that help you to oversee the arbitration, all procedure needs to be agreed by the parties or directed by the tribunal. All right. So if the arbitration clause did not provide any reference to institution, to AIC, or to any other types of procedural rules, then the arbitration will be deemed as ad hoc arbitration, and all procedure needs to be agreed by the parties. Now, your client is going to ask this: um, in which situation that it's best to go for administered? In which situation that it's best for us to go to ad hoc? We're going to discuss this in this table. Now, can I just try to ask to the audience, once again, if you have a client and then they're asking you in which situation that we go for administered, in which situation we go for ad hoc. How do you advise your client? Once again, you guys are law students. Um, After your graduation, you will be required to advise to certain clients, and I am currently now testing your ability to analyze the situation and your ability to give a proper advice to your clients.
Can I give it a try?
Sure, yes.
Okay. In my opinion, when uh, when uh, 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 when our client need to go for arbitration, especially when the matters concerning about uh, uh, where both parties want to secure their privacy. So I think it's better for them to opt for arbitration.
Okay.
However, when we talk about administered or ad hoc
Mhm.
arbitration, we need to consider whether they provide in their agreement arbitration clause.
Okay.
If both parties do provide arbitration clause where if there is any dispute involved in their in their contract. So both parties agree to opt for arbitration as solution. However, when both parties when both parties do not have arbitration clause in their agreement, if both parties agree for arbitration as solution, they as a few my few fellow participants answer that it required consent by both parties. So in that situation, the it is better and proper for them to have uh, to have ad hoc arbitration.
Okay. I'm sorry. Can I have your name, please?
Yeah,
Can I have your name, please?
Abdul Hakim.
Oh, yeah. Abdul Hakim. Yeah. So yeah.
Yeah.
Yes, you're right that first you need to look at the clause first. If the clause says ad hoc, then you have to go with ad hoc. If the clause says administered, you have to go with administered. So that's that's a very correct approach. But um, if I can clarify my questions again, is that what would your advice be if, let's say, there is no arbitration clause in the contract, and then your client and then the other party actually eager to go for arbitration, and then the next question is whether this arbitration needs to go administered or ad hoc. What would be your advice? Or maybe what would be your question to your client in order to properly advise your client whether they should go to administered or ad hoc arbitration?
Um, so basically, first of all, I will explain about what is arbitration, and to my client to make sure that they understand the result or effect of arbitration. And then when I explain about the arbitration, I will make sure they understand when in what situation they can opt for administered or ad hoc arbitration. So the main or important thing to be discussed with my client is whether they agree for the defects of arbitration, like it's required maybe a long time period. So that will be my answer.
Okay. Anyone else that? Yeah. So thank you, Hakim. Anyone else? PO4O. For administrative arbitration, it is best for it to be applied if both parties are not so familiar with the process and they need an institution to guide them in the process. Ad hoc arbitration can be applied if both parties want more flexibility in controlling the process. So I have no idea what your name is, PO4O, but you have the right answer. So this is the best answer there is. For yeah, so PO4O is I don't think you're a student. Yeah, PO4O is has a very correct answer. So when it comes to administer arbitration, it's best to be applied if both parties are not familiar in arbitration, because you will have an institution to supervise the proceeding from scratch until the end. While ad hoc arbitration, because once again, there is no procedure, um, and thus it grants more flexibility to the parties to come up with the process. So in ad hoc arbitration, it's much more better equipped for parties that has prior experience in arbitration. So if you have a client asking you whether they should go ad hoc or administered, then your next question to your client, in order to properly advise your client, is that you need to ask them whether it is their first time doing arbitration or whether they are familiar in arbitration. If it is their first time, they have no legal counsel, they have no experience in arbitration whatsoever, it's best for you to advise them to go to administered arbitration. But uh, if your client is very experienced, they are well versed in arbitration, they have legal counsel that is very prominent in arbitration, then you can advise them whether it's best for them to go to ad hoc arbitration, because in ad hoc arbitration, both parties can just agree to the procedure. So yeah, so when it comes to weighing the advantages or disadvantages in administer or ad hoc arbitration, um, the first the first advantage is that there is a procedural guidance and supervision from the institution. There's an application of neutral and institutional rules. While ad hoc arbitration, there's flexibility and it's also lower cost, because you don't have to subject yourself into an institution. So you are waiving the administrative fee. For administrative arbitration, of course, it's going to be slightly higher because there's going to be administrative fee. And then it's less flexible when it comes to procedural rules, the arbitration. And then you will subject yourself into a procedural requirement established by the institution. The cons of ad hoc arbitration is that it requires parties' cooperation in tailoring procedural rules. Now, this is one of the most disadvantaged attributes in ad hoc arbitration, because let's say you have an ex, you just broke up with your boyfriend or girlfriend. What is the possibility of you talking side by side with your ex? It's very unlikely. I mean, in my experience, it's very hard for you to be friends with your ex, let alone have a conversation um, about this. So applying that logic into a common business um, procedure, if you have a dispute with your counterpart, it's very unlikely that you are able to talk about the procedure in arbitration, let alone talk about anything. But I think if you have a legal counsel in both sides, then the personal impasse can be bypassed through this presence of the legal counsel. Okay, so now we have learned about the basics of arbitration. You have learned about what is ad hoc arbitration, what is administered arbitration. Let me explain to you about arbitration under the administration of AIC. So if I can summarize, this would be the timeline, starting from the commencement of the arbitration until the delivery of the award. And this, once again, this is going to take you at least months or even years. It depends, once again, on the difficulty of the case itself. Now, when a case is classified as administered arbitration, then as the institution, we also have to classify whether this is international or domestic arbitration, because this is going to affect several factors, such as the number of the arbitrators and then the payment of the fees. So this has to be determined at the very first instance, whether this case is domestic or international. Now, international arbitration is actually not that simple to be classified, because just because the seat is in Malaysia, it doesn't necessarily mean that it will be classified as a domestic arbitration, because there are other factors that contribute to it. For example, if you can see in the left side and B2, there is a reference that says that um, any place where a substantial part of the obligations of any commercial or other relationship is to be performed, or the place with which the subject matter of the dispute is most closely connected to. So I'm going to throw you a question. What happened if both parties resided in Malaysia, one in Cheras, one in Kedah, and the performance of the obligation, actually, most of them are in Singapore? Is that going to be classified as international or domestic arbitration? Um, Very quickly, I think that is possible to be classified as international arbitration, because the requirement of B2 will be satisfied if the substantial part of the obligation is carried out outside Malaysia, in a state other than Malaysia. So when you are about to commence the arbitration, please take note of every single notable performance of the obligation of the contract, because just because your parties, both of them are residing in Malaysia, it doesn't necessarily mean that that will be classified as domestic arbitration, because there are other factors that will come into play. Now, when you want to commence the arbitration, it's not as simple as just writing to us saying that we want to commence arbitration. It's not that simple. There are other requirements that needs to be fulfilled. If you see in our rule 2, paragraph 1A, first, you need to provide a copy of the agreement to arbitrate, arbitration clause that reflects the agreement of the parties to refer the dispute to arbitration. That's for sure. The second one is the contract, which contains the arbitration agreement. The third one is the notice of arbitration that you have served to the respondent. And the last one is the just proof of payment for the registration fee. Now, this all documents needs to be sent to AIC if you want your matter to be administered by the AIC. Now, some of you might not have the opportunity to see an example of arbitration clause. So this is the example of what is agreement to arbitrate based on AIC model arbitration clause. We're going to talk a lot more about this later on the second part. I'm going to talk to you how to detect a defective arbitration clause and how to draft a proper arbitration clause in the second section. But for now, this is the example of what is agreement to arbitrate. Any dispute, controversy, or claim arising out of or relating to this contract, or the breach, termination, or invalidity thereof shall be settled by arbitration in accordance with the AIC fast track arbitration rules, or other kind of rules that we have. We have AIC arbitration rules, the normal one. We also have AIC Islamic arbitration rules and the fast track rules as well. Now, the first part is mandatory. The last part is the recommended toppings to the clause itself. You can also agree on the seat of arbitration, the language, and the governing substantive law. Now, there's a difference between model arbitration clause and model submission agreement. So arbitration clause is something that you can find in the contract. That before a dispute arises, the parties contemplated that if in the future a dispute arises, this dispute shall be settled through arbitration. So that is arbitration clause. Now, submission agreement is different with that. Submission agreement, usually it requires to be submitted if the contract did not contain a clause, but after that the parties agree to submit their dispute to arbitration after the dispute arises. So once again, the clause, this is something that you can find in the contract before a dispute arises. Submission agreement is something that you cannot find in the contract, and you need to submit that after a dispute arises because the parties agreed after a dispute arises that that dispute needs to be settled through arbitration. Right. So that's the cost. The next requirement, if you want to commence the arbitration, is the submission of notice of arbitration. Now, AIC do not have a template. We do not have a like the setting, formatting, or a specific requirement. What is an NOA? But if you take a look at UNCITRAL arbitration rules, this is the requirement of the NOA. First is that you need to give a detail of the parties. You need to submit a demand that the dispute needs to be referred to arbitration, a brief description of the claims, and a lot of elements that you need to capture in your notice of arbitration. So this needs to be served to the respondent, and after you serve that, you need to give it to AIC so that we know that the NOA has been served to the respondent. Now, as I mentioned before, AIC rules, we have AIC arbitration rules, AIC Islamic arbitration rules, fast-track rules, mediation rules, and we also have AIC adjudication rules. So although our name is Asian International Arbitration Center, but we would like to be known as a center for ADR, Alternative Dispute Resolution, because our service does not only stop in arbitration, but also in mediation, in adjudication, and other types of ADR as well. All right, so back to AIC arbitration rules. So if you notice, right, any other institution, not only AIC, we keep revising our rules. We have rules in 2018, 2017, 2010, 2013, another one in 1990s. So all of these changes, right, it doesn't mean that we are inconsistent or there are something wrong with our rules that we need to keep revising. The reason why there needs to be a regular update to our rules is that every year, every 2 years, 3 years, or every single year, there's always new in arbitration industry. There's always something exciting, something, some new trend coming up every single year. Now, if an institution do not keep up with that, we're going to be seen as outdated. So the reason why we need to keep updating our rules is to make sure that our rules stays relevant and then our rules, keep up with the trend. Now, our latest rules is 2018. This captures a lot of new features like we have joinder, we have emergency arbitration, we also have technical review, and then the power to award interest to the tribunal. For this one, so just for your information, this is not rules meant for Apple users or iPhone users. The I stands for Islamic arbitration rules and does not stand for iPhone or iPod or whatsoever. It stands for Islamic arbitration rules. The reason why it is Sharia compliant is because we have what we call in Rule 11, we allow the tribunal to consult with a Sharia counsel or Sharia expert. I think this is relevant, for example, when there's a dispute whether this financial scheme can be called as riba or not. And as you that learn about Islamic law, you would learn that there are a lot of elements in order to be called as riba or illegal or interest. Now, because there are a lot of elements of this riba, and then not every single person can determine, can interpret what is the element of riba, then the tribunal can invoke Rule 11 to ask Sharia counsel what is the element of riba. So that's called asking for hadith for the interpretation by the Sharia counsel. And because of this, we want a innovation award back in Colombia in 2012. We also have a fast track arbitration rules. So this is useful for a dispute where the amount of dispute is small, and then you want the dispute to be settled very fast. So under this dispute, if your amount of dispute is below 500 a ringgit, then that dispute should be solved documents only. So no hearing, just documents. And if you proceed with documents only basis, um, the dispute will be solved very quickly because you don't need to call hearing. And we saw one case where it solved just within few weeks. That's less than a month under AIC fast track arbitration rules. Um, but there's a drawback in fast track arbitration because a fast proceeding means that you have less time to submit your case. So that might jeopardize your opportunity to submit your case properly in fast track arbitration. We're gonna play scenario later to um, to utilize the fast track arbitration rules later on in the second session. Now, facilities. So when it comes to costs, right? As you guys mentioned just now, cost in arbitration is very high, and AIC is very aware of that. So that's why we're trying to minimize the cost as much as possible. So AIC, right? We have been rated as the cheapest institution in the world, in the planet. As you can see at the right corner, we have been rated as the cheapest. Um, Daily users in our facility, they only spend around 200 US dollar per day. But if you take a look at, for example, the highest one, ICC, for example, per day, they need to spend like almost 3K US dollar. So that's 15 times cheaper, 15 times more expensive than AIC. And not only we are the cheapest, we also have the highest number of hearing rooms. So this is something that I keep telling the students in Malaysia, right? You guys are so lucky to have institution like AIC because back in my country, back in Indonesia, we do not have an institution that is as big as AIC with this number of hearing rooms and then with the commitment to the youth, with the commitment to education as high as AIC. So please, use this benefit as much as possible. Go to AIC for research. Our library is open if you guys are near Kuala Lumpur area. Feel free to come to AIC to do some research. That's very easy to be arranged. Oh yeah, so that's the first part about the features of arbitration and then the administration under AIC. You guys have learned the first part. Now we're gonna move on to the second part, which is the arbitration agreement. But before I move on, I just want to check whether you guys have any questions before I move on to this second slide. All right, I see that there's no question, but feel free to throw any question in the first slide during my presentation for the second slide as well. Feel free to do that. And can I just check with the MC that I still have 30 minutes left, right?
You have about 30 minutes left.
Oh,
Until 3:20, we shall begin with our Q&A session.
sure.
Thank
Can
you.
you please help me to give me a time reminder if I have spent around 20 minutes?
Yes. Thank
Thank you so much.
Yep.
Okay, so we're gonna move on to the second part, which is the fundamentals of arbitration agreement. So as most of you have noticed just now, you need to have consent in order to initiate an arbitration, right? If there is no consent, we cannot initiate an arbitration. And then most of the consent will be reflected in the arbitration agreement or arbitration clause. Now, it's actually not this simple because there are a lot of things that can go wrong with arbitration agreement, and I'm going to explain to you why. All right. Um, I'm going to throw you guys a question. And please feel free to drop your um, answer into the chat here. Can you help me to dissect, to divide this clause into three, three elements? Can you see three elements in this model arbitration clause? If you guys are a doctor, surgeon, can you dissect this clause into three parts? And part constitute as the minimum standard of arbitration clause.
Hello.
Mm,
Can you guys hear my voice?
I I can hear your voice, but there is a background noise as well.
Oh, so maybe for the course there, the three parts is firstly the type of ADR. Uh, Secondly is the governing rules for the ADR,
Yeah,
and also lastly maybe the reason for the ADR process to be taken.
the reason.
I that phrase of any disputes, controversy, or claim arising out of.
Okay, okay. And the first one, sorry, the first one is what again?
This one is on the type of ADR that the parties agreed to,
The
which
type
is
of idea, yeah?
the
Thank you
application
so
there,
much.
and then the governing rules for the ADR. So the
Okay,
AIX application rules,
okay.
if
Sorry.
I'm not mistaken.
Yes. Can I have your name again?
You can call me Fitri.
Fitri. Okay.
Yes.
So Fitri, thank you so much for your answer. Are absolutely right. So there are three elements. There are three minimum elements in arbitration clause. The first one, as you mentioned, I think you mentioned reason, but the correct classification is scope of dispute. So the first is the scope of dispute, and that's starting from any dispute, controversy, or claim arising out of or relating to this contract or the breach, termination, or invalidity thereof. That's the first element. We call that scope of dispute. The second one, you mentioned about the type of ADR, and in this case is arbitration, and that is absolutely correct. The second element is that there needs to be agreement of the parties to arbitration, and in this case is that shall be settled by arbitration. So the parties agree to refer the scope of dispute to arbitration. That's the second element. The third element is that in accordance with the AIC arbitration rules, or as Peter said, the agreement on the application of governing rules. Now, it doesn't necessarily need to be AIC arbitration rules. It can be either rules or it can be just a simple um, Arbitration Act 2005. That's also possible. But the underlying issue is that there needs to be agreement on the rules, either institutional rules or a governing arbitration law. So that's the third element. So thanks, Viti. That's a very good answer. So as you mentioned just now, there are three minimum standards: scope of dispute, parties agreement to arbitration, and the applicable rules. But is that all? Is that all? You know, all the things that you can agree in agreement to arbitration? The answer is no. There are a lot of other things that you can add into the arbitration agreement, and this is what leads us to the other part of the discussion, which is consideration in drafting arbitration agreement. So the first issue is that you have to decide whether it is administered or ad hoc arbitration. And based on our previous discussion, this depends on the party's experience. Are you experienced user or are you first timer? If you are first timer, then you need to include administered arbitration, and you have to apply a certain institutional rules, and then the cost as well. And if it is administered, which institution? Um, if you are based in Malaysia, the parties are based in Malaysia, maybe it's easy for you to say AIC. But what happens if your company is in Malaysia and then the other party is in Indonesia, and then because of that, you cannot appoint institution either in Malaysia or in Indonesia? How do you select which institution? So this actually has been discussed in a survey by Queen Mary University of London. Um, there are a lot of consideration that you need to take into account, such as high level of administration, the neutrality, the global presence, ability to administrate arbitration worldwide. So there are a lot of things that you need to take into account. And then which set of rule that needs to be applicable. As we discussed just now, in AIC, there are three arbitration rules. You have the normal rules, you have the fast track rules, you also have the Islamic rules. And this needs to be tailored in accordance with the need of parties. And then how do you want to appoint the arbitrator and how many? Um, the last one, not the last one, the next one is the seat of arbitration. So seat of arbitration is different with the venue of arbitration, yeah? Seat of arbitration means that the legal arbitration hearing is held. So it is possible that the arbitration is conducted in Singapore, but the seat of arbitration is in Kuala Lumpur. That's possible because venue is just the physical place of the hearing, but seat is the legal juridical place of the arbitration. Okay, these also the factors that you need to take into account when you determine the seat of the arbitration. Okay, you might notice that I'm going a bit fast because I am aware of the time constraint, and then there's actually a bit of exercise that I would like to spend ask more time on that. So bear with me. The sixth item that needs to be discussed in the agreement to arbitrate is the language of arbitration. The substantive law, the number of the arbitrators. You know, if you want to be cost efficient, then sole arbitrator is a way to go. But if you are worrying about the quality of the arbitral award, then three members of the tribunal is the way to go, because a product of from three brains is better than a product of a single mind, a person will say. And then this is what we call as condition precedent clause, or what people call as well as waterfall dispute resolution clause. So a waterfall dispute clause means that it's just like a waterfall. You know, you have a tier. You are starting from the top until the bottom. So when it comes to waterfall dispute resolution clause, the dispute needs to be resolved by, for example, negotiation first, in which that needs to be settled through mediation, in which this needs to be settled through arbitration. So this step is called as waterfall dispute resolution clause. You know, before referring a dispute to arbitration, there are certain pre-arbitral steps that the users needs to comply, be it mediation, be it negotiation or conciliation or any other types of amicable dispute settlement. That's what people call as waterfall dispute clause. And whether they are emergency arbitrators provisions and expedited procedure provisions. Okay, now we're gonna go with the fun part. We're gonna try to detect defective arbitration clause or invalid arbitration clause. So there are a lot of ways where you can mess up an arbitration clause, but the three principal defects lies on first, inconsistency. The second one is uncertainty, and the last one is inoperability. All right, for inconsistency, for example, this happened in Shagang, South Asia, Trading Limited versus Daewoo Logistic Corp back in 2015 before the English Wales High Court. So as you can see here, right, there are two dispute resolution clauses. The one contained in the 2008 fiction note and the other one contained in the GenCon 1994 form. The fixture note dispute resolution clause provides that the arbitration to be held in Hong Kong, English law to be applied. But the other part says that English law to be applied, but the arbitration is to be held in London. So the question is whether the arbitration to be held in Hong Kong or to be held in London. So this inconsistency can cause an issue, and this actually really often to happen when you have a lot of contracts in the projects. You have more than one contracts, and in each of the contracts they have a different dispute resolution clause. Now, those inconsistency can contribute to the defect of the clause itself. So if you are a legal counsel, make sure that in a project where you have a chain of contracts, those chain of contracts have a consistent dispute resolution clause. Otherwise, it's going to be a problem later on. I think what happened in this particular case is that the judge decided Hong Kong to be the proper place for the arbitration to be held, taking into account the conduct of the parties during the negotiation of the contract. Because I think when the contract was negotiated, that the parties lean towards Hong Kong more than in London. So yeah, so the judge took into account the conduct of the parties when it comes to repairing inconsistent arbitration clause. Now, this is an exercise that I would like to you all to participate. Now, these examples of the clauses that lack of uncertainty, that lack of certainty. So all of these are unclear. All of these clauses have been founded as defective because they are not clear. Now, I'm gonna ask to you all, and once again, same exercise, feel free to drop your answer into the chat. Let's go with the first one. The first one says that in the event of any unresolved dispute, the matter will be resolved to the International Chamber of Commerce. What's wrong with this clause? What makes this clause unclear? For MC, can you help me to let me know whether, oh, sorry, now I can see the chat again. Okay. Can anyone tell me what's wrong with the first clause? P113, the scope of dispute. So the scope of dispute is there. You have, in the event of any unresolved dispute, you have the scope of dispute there. But how about the other two elements? As we discussed just now, there are three minimum standard elements of arbitration clause. Which of these three that is missing in this clause? The governing rule and what type of idea? So P191, P172, and P251, yes, you guys are correct. Because first, there is no agreement that the matter will be resolved through arbitration. It only says will be referred to the ICC, International Chamber of Commerce. But once again, ICC, they have a lot of services, not only arbitration, they also have mediation and other part of ADR. So only reference to ICC is not enough. So there needs to be an agreement to arbitration and then the type of ADR. So yes, you guys are right. No reference to arbitration as the method of dispute resolution, and then there's also no reference to the application of governing rules. Okay, nice job. How about the second one? Can anyone tell me what's wrong with the second clause? All disputes arising in connection with the present agreement shall be submitted in the first instance to arbitration. The arbitrator shall be a well-known chamber of commerce like the SEC, designated by mutual agreement between both parties. Can anyone share with me why this clause is invalid? Why this clause is uncertain?
There is no governing rules.
Yes, there is no governing rules. Um, but anything else that you spot here that makes it uncertain? I think for this clause, we need to step outside a bit from the three minimum standard. The number of the number or choice of arbitrators. The number is clear. You have a single arbitrator there. The choice of arbitrator, you are correct. Choice of arbitrator is unclear. Here it says that the arbitrator shall be a well-known chamber of commerce. As you know, that arbitrator needs to be an individual, right? It cannot be an entity. And in here, reference of chamber of commerce is an entity, it's not an individual. I think what the drafter of this clause is trying to say is that the arbitrator shall be empaneled by the ICC, by a well-known chamber of commerce like the ICC. But you know, somehow the drafter messed up the work and it's becoming like this. So the reason why this clause is unclear is because unclear appointment of arbitrator. Once again, arbitrator shall be individual, cannot be an entity. How about the third one? Can anyone tell me what's wrong with the third clause? Any and all disputes arising under the arrangement contemplated hereunder will be referred to mutually agreed mechanism or procedures of international arbitration, such as the rules of the London Arbitration Association. Anyone want to try?
I think it is the mechanisms and the procedure are not specified clearly.
Okay. Can I have your name again? Yes. Can I have your name again? The one that just answered. Sorry, because I cannot see the
P147.
Iwan.
P147.
Okay. Yes. So you're right. In this case, there is it requires somehow a featural and hypothetical agreed mechanism because they say that the dispute will be referred to mutually agreed mechanism or procedures. So there needs to be another, discussion that once a dispute arises, let's talk about that later on and let's agree on mutual agreed mechanism. So this is unclear. Now the last one is what we call as disastrous compromise because um, you're not sure whether the dispute will be referred to a tribunal or in litigation. So it's what we call the disastrous compromise. So you need to be clear whether your dispute will be referred to litigation or under a tribunal. So this is just a mere example of clauses that lack of certainty. The next one is the clauses that is inoperable. Now, the terms of inoperative actually, it means that the clause actually valid, but in order for you to activate the clause, there are certain conditions that cannot be met anymore, and that's why it's inoperative. For example, if the clause says that within 30 days from the emergence of the dispute, the parties can refer the dispute to arbitration. And what happened if the dispute were referred on the 31st day after the dispute is emerged? So that would be one of the arguments to say that the clause is inoperative because there is a precondition that cannot longer be satisfied. So yeah, that's an example of inoperative arbitration agreement. All right, the next topic that I would like to discuss with you all is what we call as the concept of separability.
I'm sorry to stop you there, Mr. Audio. You have about 5 more minutes to Q&A session.
All right, okay.
All right, thank you.
Okay, very quickly, the concept of separability means that if contract is terminated, it doesn't mean that the clause is also terminated. So for example, if you bring a dispute to arbitration because of invalid termination of contract, and then your opponent says that, oh, you cannot rely on the arbitration agreement because the contract is invalid. So your defense to the argument is that concept of separability, just because a contract is deemed to be invalid, is deemed to be terminated, it doesn't mean that I cannot invoke the arbitration because it's separate from the main contract. That's the concept of separability. Okay, very quickly, guys. Can you, as the MC just told me just now, I only have 10 minutes. Can you all quickly tell me whether this clause is invalid or not? Quickly, hurry, in the chat function. For those who cannot read, there's a quote there. It basically says that the law of the Federation of Malaysia, without giving effect to its conflict of principles, govern all matters arising out of or relating to this termship. Is this a valid clause or not? And why? Very easy, guys. From those three standard clauses, from those three standard elements of arbitration agreement, can you find that here?
No, the three elements are absent.
Correct, absolutely correct. There are no single one element here. The next one, will the arbitration be administered or ad hoc? Any dispute which relates or arises out of this contract shall be resolved by having dispute settled at the Asian International Arbitration Center.
Mr.
Right. Are you sure? Now, this is very tricky because people are typing administered, but actually it is not administered. Can someone tell me why it's not administered? It's very tricky. It's just because of one word. Remember, how do you classify administered or ad hoc? It can be classified as administered if the clause makes reference to institutional rules. So applying that logic, why this clause is not administered? Can anyone share with me?
Hi, is it like at the AIAC but not stated that by AIAC?
That is correct, because the wording says that shall be resolved by having the dispute settled at the AIC. It means that the hearing of the arbitration will be located at the AIC, but it doesn't say anything about the application of AIC arbitration rules. So because of that, this is ad hoc arbitration, not administered. And for those people that just say administered, congratulations, you just wrongly advised your client. So this is very little, right? This is very trivial, but this little thing actually gives a lot of impact to your client, to the proceeding. You know, you just have to be very, very keen when it comes to this. But yeah, I think I'm running out of time. I actually still have a lot of other exercises, but I will leave it from here. So thank you very much, guys. If you guys have any questions, please let me know. So back to you.
All right. Thank you, Mr. Aldio, for the insightful sharing. It is indeed informative to all participants who are with us today. Now we would like to open the floor for the Q&A session. Again, to remind all of you, you may unmute your microphone, or if you are shy, you could directly ask through the chat box. While everyone is typing out your questions, I think I would go first. So, Mr. Audio, I would like to ask which types of clients would usually prefer to go for arbitration or the mediation instead of going to the court?
Oh yeah, thank you. So we see that people, they prefer to go to arbitration first when they have exhausted any other types of dispute resolution method available therein. Like they have exhausted to try to mediation, they have tried negotiation, but the dispute fails. And the clause provides that if there are no other method to settle the dispute, then the dispute needs to be referred to arbitration. So yeah, so that is for arbitration. They have tried any other alternative, but then it's failed. So that's why they went to arbitration. For mediation, I think it's those users that is still believe that there's a chance of amicable settlement by the other party, and then the other party is also cooperative to talk about the issues to the other party. For the court, I think it's simply because they just want to have something straightforward, and they don't have any other alternative dispute resolution available in their contract. So that's why they just go straight to the court.
Is there any other questions from the participants?
Yes. So I would like to ask, during this time of pandemic, right? So how did exactly that the AIAC governed or conducted the arbitration processes? Maybe throughout the online platform like we did right now, Zoom, or maybe other online platform?
Yes, thank you for the question. So during this pandemic, we have to innovate to provide more flexibility to our users because we are located in Kuala Lumpur, and then Kuala Lumpur, as you know, is currently under our MCO. So because of that, we cannot open our hearing room. But as an alternative, we do provide virtual arbitration proceeding service. So it's like a Zoom like this, where the parties are inside the Zoom, and then there will be one IIC staff that help to oversee the proceeding. So yes, we have it visual. And when it comes to the documents, usually the parties will just submit it under like Google Drive or Google Docs. They will still have to submit the documents hard copy as well if the tribunal require. But Google Documents sometimes are sufficient as well. So yeah, we still provide our services in visual.
I see that we have a question here. Roughly, will an arbitration competition be conducted similarly to a mooting competition? And do usual mooting rules apply?
I see. I think this is coming from
POs
yeah, from
40.
or I mean from people that have experienced in mooting in court setting, and then are eager to learn more about mooting in arbitration setting. So I can say that mooting in arbitration and in litigation, they are very different. They are two different animals. In litigation, you have just for the formalities, you have to stand up, and then you have to do a pleading in front of the podium, and then you have to address very formally to the court. You have to say, "May it please the court, Your Honor, my Lord, my Lady," and whatsoever. So it's very formal. But when it comes to mooting and arbitration setting, it's much more informal. It's more like you know, just like a conversation like this, where you're just trying to have a discussion, a conversation with the arbitrator, but at the same time, you also have to afford a reasonable amount of respect to the tribunal. Like when you address something, you have to say at least Mr. Arbitrator or Madam Arbitrator and not just call it by name. So it's less informal, but yeah, it's two different animals.
And we have one more question. Dear speaker, I would like to ask, can we cite an award from other institution? For example, the ICC award in an AIAC arbitration, or we shall restrict ourselves to only refer to those settled in AIAC.
Okay. So as we discussed just now, in arbitration, there's no principle of stare decisis. So it means that there is no binding precedent. So even when you cite a case, right, it's actually not binding anyway. It's just a highly persuasive authority. So because of that, you have the liberty to cite any types of arbitration award available there are. So even though you're having your arbitration in AIC, it doesn't mean that you can only cite an award from AIC. You can cite award from ICC or from LCIA, from other institution as well. But one thing that you have to note is that, as we know just now, arbitration is confidential. So it's very hard for you to actually acquire a arbitral award from other institution unless the parties are okay to have it released, or when certain part of the award has been redacted to protect the confidential information um, from the parties, like maybe any other possible identifying information from the name of the parties, from the address. So yeah, long story short, it's possible for you to cite any other award from other institutions as well.
Is there any more questions from the participants? All right, there's one. Sorry for asking, Mr. Audio. May I ask, is the legislation like Contracts Act or any other legislation in Malaysia still applicable for the argument?
Yeah. It is still applicable, but remember that there are certain boundaries. Like for example, Evidence Act is not applicable when it comes to witness examination in arbitration in Malaysia. So there are certain legislation that is still applicable, like the Contracts Act, Companies Act is still applicable, but there are also some legislation that you cannot cite and not applicable in the realm of arbitration, like the Evidence Act. And while waiting,
Sorry for asking. Good afternoon, Mr. Audio.
yeah,
May I ask, so how can we check on the legislation that we can use in the argument of the arbitration setting, competition, something like that? How can we check on that?
First, I think you need to check on the legislation itself. I think the legislation will be clear whether this act can be used for arbitration or not. I think after this act, there is a specific paragraph there that says that this legislation is not applicable in arbitration. And the second one is that I think you can also check the arbitration act itself, because I think the act also says that there are certain provisions that is not applicable in the arbitration. But as far as I know, I think only Evidence Act that is not applicable. But correct me if I'm wrong. So I think you guys have more insight in Malaysian law than I am.
Thank you so much.
Yes. And while waiting for more people to type in more questions, right? I just would like to give you a heads up that I think in 2021 there's going to be a lot of moot court in arbitration setting that's going to starting to open up their registration. I think the first one would be Low Asia back as not back, but in this March. There's going to be registration for NAMCO as well. And then CVIS, the Vismut is going to open their registration, I think October or June this year. There's also going to be Islamic arbitration with competition as well. um, yeah, I think there are going to be a lot of arbitration moot competition. So please be on the lookout. I think AIC, if you guys are in our subscriber, you guys will receive notification regarding that.
Do we still have any more questions from the participants?
Okay, one last question.
All right.
All right. Okay. Could we say that what could someone like us as the law student have the ambition to be a full time arbitrator?
Ah, so in order for you to be, so there's actually no requirement or admissions, like if you want to be advocate under the High Court of Malaya, you have to get a privilege, you have to get a you have to pass CLT, la 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 la. But when it comes to arbitration, there is no such thing as that. So there is no requirement of you to pass certificates. Like if you know about fellow CR, it's actually not a requirement. You can still be appointed as an arbitrator, even though you don't have those kind of certificates. But one thing that that you might learn from today's discussion just now is that who actually appoint the arbitrator, who actually have the power to appoint the arbitrator. Um, is it only the institution? No. The parties, they have the power to appoint you as the arbitrator. So the next question is, how do you get parties? How do you get people to appoint you as an arbitrator? And then one thing is that you have to have a reputation in arbitration. And the next question is, how do you build your reputation in order to be known as a well-known arbitration or arbitrator? There are a lot of ways for you to build your reputation as an arbitrator. You can start as a as an academia. You can start lecturing people in arbitration, or publishing book, publishing journals. You can start as a practitioners, as a lawyer specializing in arbitration or dispute resolution. You can also start like an AIC case counsel, work in an institution so that the how do you say the bird eyes view from the arbitrator, from the claimant's respondent's perspective. So there are a lot of ways for you to get appointed as an arbitrator. But one thing for sure is that you have to get the reputation. So how do you build your reputation? It is up to you. I hope that answers your question.
All right. Thank you, Mr. Aldio, and to all participants who actively engaged in our session today. It was indeed really insightful and informative. I could see all the structure in the slides, and I could see it's really clear and precise. On behalf of the National Mood Workshop Committee, we would like to express our gratitude to Mr. Aldio for spending his time together with us. Now we would like to end this session with a photography session. May I have everyone to turn on your camera, please? Ready?
Yes.
1, 2, 3, smile. Again, 1, 2, 3, smile. Okay, thank you. Please stay at the end of our session for the closing ceremony. And once again, thank you, Mr. Audio, for your presentation on arbitration today.
Yes. Thank you so much for having me, and Happy New Year to you all.
Thank you, Mr. Audio. Now it is time for the closing ceremony. Let us call upon Mr. Abdul Hakim bin Ahmad Termizi, the Director of National Mood Workshop 2021, to deliver his speech. Remember to unmute yourself.
All right, thank you, Fianzin Yu. All right, first of all, Assalamualaikum and good evening to everyone. And first, thank you, Mr. Audio, all the organizing committee, and all participants for National MOOC Workshop 2021. So today is a wonderful day. We are sitting in front of our laptop, the same as our regular day in lecture and tutorial class. The only thing that makes it different is we are the one who choose to be here. To all participants of National MOOC Workshop 2021, I believe each one of you have a huge dream, and becoming lawyer might not be part of it. Little did you know, every second that you spend today in front of your laptop worse than doing nothing during your weekend. Throughout this one-day workshop, I am sure that everyone already gets some insights from the experienced mooters, tips and technique during research and submission, and the basic knowledge on arbitration. With that, I really hope that this workshop will be your first baby step to embark your journey as a mooter or researcher in mooting competition. To all committee and panel of advisor of National Moot Workshop, I wish to let you guys know that each one of you is the sole reason for the existence of today's workshop. I still remember the days of preparation for National Moot Workshop, interviewing all the committees and our recent rehearsals. I know some of you are busy with your studies, and I believe your commitment for the preparation of today's workshop was to be shared. Before I end my speech, I wish to congratulate all of you for participating in today's workshop. And personally, I want to congratulate, or I want to thank to, I realize that there are several my colleagues during UITM Dinkil Friends for supporting to the workshop, Shafiqah and Aisha. And then I left everyone with a quote from Master Uwe of Kung Fu Panda. My time has come. Therefore, I wish good luck to everyone and all the best.
Thank you, Mr. Abdul Hakim, and thank you for that quote. Your time has come. Next, we are pleased to have Ms. Nur Fatehah binti Nohaimi, the Vice Director of National Moot Workshop, to deliver her speech.
Okay, Assalamualaikum and a very good evening to everyone. I won't take as much time. So, but as the Vice Director of this program, and also on behalf of the collaborators, all panels of advisors, committees, I would like to thank all the distinguished speakers and also the participants for joining this program. I hope that you can gain as much knowledge as you can from the starting of the program at 9 a.m. until this evening. So thank you so much for joining, and have a great day ahead, and Happy New Year, everyone. Thank you.
Thank you, Ms. Nur Fatehah. Before we end this workshop, may I please request all the participants to open your camera for a photography session? Just this one last time, and before we end. All right, ready? 1, 2, 3. 1, 2, 3. Okay, I have it. On behalf of the National Moot Workshop Committee, we would like to extend our gratitude to all who joined us today, the panelists and also the participants as well. And I would like to convey my deepest apology for any inconvenience caused throughout my duty as the MC. This workshop has come to an end. Thank you and Happy New Year. Bye, everyone.